My name is Beth Persky. I'm with the Federal Bar Association's International Law Section, and I'm here to introduce our great panel on litigation impacts, the General Data Protection Regulation, California Consumer Privacy Act, and a possible Federal Privacy Act. We have the Honorable Suzanne Segal moderating, and we have Joel Richlin of Prime Health. We have Jeff Tsai of DLA Piper, and we have Dominique Shelton Leipzig of Perkins Coie. I'm sorry. And I just wanted to say on behalf of the International Law Section, our goal is to bring some international topics to Los Angeles and some other cities. So this is our first effort at doing that. The program will be available on demand also. And I wanted to make one other announcement. There are still seats available for the Beverly Hills Bar Association Entertainment Law Section's 2019 Entertainment of Lawyer of the Year Awards. And that is taking place on Thursday, May 2nd at the Four Seasons Los Angeles. And I believe the information is available on the Beverly Hills Bar Association website. So I want to just go ahead and leave this to our wonderful panelists.
Thank you so much. So thank you everyone for joining us this evening. And I wanted to thank my panel members before we even start, because I think most of them were doing this just to be nice to me, and because I asked them to. This topic of the GDPR and the California Consumer Privacy Act and the impact on federal litigation is obviously a topic that's something of great interest to my court, and I think to the federal courts around the United States, because we see this as an area where it's kind of an unknown and uncertain area that we're going to have to address as time goes on. And so we're looking to the experts here to help us answer all the questions in our mind about these acts. I think everybody can relate to the situation of having your personal information, your email, your phone number, or other information taken in some way or used in some way or sold in some way that you didn't appreciate. And I think that's the origin of many of these privacy statutes, that they are to address consumers' interest in protection of their personal data for commercial use or for other kinds of use by individuals they don't want to be using their personal data. And I think it's a very complicated issue right now in California as to how, and I was just talking to Dominique about that, how those tensions between the desire of the commercial world to use your personal data for financial interests is going to be weighed against every consumer's interest in protection of their private information. So without any further ado, I do want to introduce our panelists because they're very distinguished here. So to my immediate right is Joel Richlin. Joel is the Vice President, Deputy General Counsel, and Chief Litigation Counsel for Prime Healthcare, which is a very large healthcare company, owns many hospitals in many states. And before that, he was a senior counsel at Foley & Lardner. Before that, I was lucky enough to work with Joel at the district court. He worked with 3 different judges at our court, all of whom regret the moment he left. So we're very pleased to have Joel with us on the panel. To Joel's right is Jeffrey Tsai. Jeffrey is a partner at the DLA Piper law firm and represents companies in civil and criminal enforcement matters, and leads DLA Piper's efforts nationally in helping companies subject to investigative scrutiny by individual multi-state attorneys general. He's probably the perfect person to defend people if they are accused of a data breach or other such problems. Has much interesting work in his background, but in particular served as an assistant United States attorney and the deputy chief at the U.S. Attorney's Office in Miami, and senior counsel to a former assistant United States Attorney General for the Justice Department's Criminal Division. So a lot of good background to lead our discussion on the GDPR today. Finally, Dominique Shelton Leipzig is a partner at the Perkins Coie firm, and she heads up that firm's privacy and cybersecurity practice and is an expert in all things relating to privacy and data management, and recently has been testifying, as we were talking about over dinner, in front of the California Senate on some proposed amendments to the California Privacy Act. So again, a real expert, and we're very grateful to have you here. So with that, I'll turn it over to Jeffrey to talk about the GDPR.
Great. Thank you, Judge. And it's great to be here tonight. Thanks to the Beverly Hills Bar Association and certainly the Federal Bar Association for having us here and having me here. Happy to be talking about an issue this important. I'll also say, mercifully, I have the least number of slides, so that'll be very good. I'm really proud to be part of this panel because Dominique is a former law partner of mine, which I'm particularly proud of, and I work with Joel, and I had the pleasure this evening to meet Judge Segal and hear some of the stories about Joel, which it's being recorded, we can talk about those. That makes me want to hear more about them, the fact that he's saying no to those.
I need another counsel. DLA has been great, but I don't know.
So we have a few slides, and my area is talking about the GDPR, which really represents probably the biggest sea change in data protection and data security in the world, which is a pretty dramatic statement. And that's probably only rivaled by, as Dominique will talk about, and certainly Joel will too, what's happening in California specifically. But I think in many ways, talking about the GDPR at the forefront is a good jumping off point to something as dramatic as this notion of a sea change in data security. GDPR, of course, emanating out of the EU, the General Data Protection Regulation that came online in May of 2018. And I think that in many ways, despite how extraordinarily complex the regulation is, both in terms of its specific scope in terms of what's written on paper, but also the manner in which it's been implemented across the EU and more than just EU states across the European Economic Area. So, right, a more expansive area than just those states that are part of the EU. And on top of that, countries all around the globe, including, but not limited to, the United States. But the GDPR, for all that it is, and for a little bit for what it isn't, in essence provides far more transparency for data subjects, as they're called, people whose data is at issue, and a lot more obligations for what companies have to do, the people who are called the processors and the data controllers themselves. And that's pretty significant because the issue of transparency is probably the kind of the watchword in privacy conversations, is how much are people entitled to know, both in terms of things that are going to happen to their data, how their data is going to be used, and to the extent that data itself is a pretty complex topic, it has very real-world implications, whether you're talking about Californians here or you're talking about people in Belgium, because ultimately, this is the things that are transacted on a minute-by-minute basis over the internet and goods and services that you buy. So we talked about this notion that it's greater transparency, it's more robust options, to be sure, for consumers themselves, and it also, in many ways, as I have kind of on the slide here, a mention of the fact that it's not just data that belongs to adults, which is what we think of, the primary users of the internet for purposes of commerce, but also for children too, and a lot more regulations that are applicable to what data controllers have to do in terms of underage users of the internet. Also, as a particular concern, of course, for Americans, for Californians, for sure, this is going to be the implication for the California Privacy Act that's at issue, is this applies for sure to United States companies. To the extent those companies are multinational in scope, to the extent that they have a specific presence in the EU, to the extent that their business targets people in the EU, this certainly is going to have an impact, and already has had an impact for U.S. companies. So let me go to the next slide. Thanks, Joel. I'm going to break this down for the two things that I mentioned before, is that primarily what we're talking about is a big change for rights for individuals and obligations for company. The rights for individuals are the kinds of things that you're already starting to see on a lot of websites and a lot of things that you do as a consumer. And some of those things relate to, for example, the right to information. That is, more information that you're entitled to about how information and data is collected and how your personal data is used. The right of access, that is to say, your ability to go to a data controller and get that information when you want it and get a copy of that. And that's, for example, something you can do right now by going to any of the big data controllers out there, Google, for example. You also have the right to have data fixed. That is to say, through the GDPR, one of the most interesting fundamental changes is that if there is information that is about you that is wrong, even if that's not information that you provided in the first instance, you can have that corrected too. And you also have the right to have information erased about you. One of the most interesting public policy issues that affect a lot of lawmakers here, for example, in California, across the country, it's a federal issue that's being discussed too, is the ability for people who are victims of exploitation to be able to go to the data controllers to say, I want this information taken down. And that's something, for example, that has been hotly debated and legislated here in California in talking about things that's more commonly known as revenge porn, right? This idea that there is the exploitation going on of people by using their personal information in a way that is exploiting them, obviously, without their consent. That's a lot of what the GDPR emanating out of the EU is now changing across the globe. There's also a lot of rights that are built into the idea of your ability to have greater agency over your own data, whether that relates to portability, your ability to take that information and obtain it from the data controller, to have it in a usable, machine-readable way. Your ability to stop data controllers and processors from processing your personal data. And fundamentally, as we'll talk about in a second, a lot of this is tethered to the obligations now that these companies have and what they can do, what they are allowed to do and what they are not allowed to do with respect to your data. And then one of the other most important rights relates to, as you've probably heard about, this idea of the right to be forgotten, which is something that, as you know, right now, to the extent you want to try it, I've tried it before, unfortunately, there's a lot more about you than you may think on the internet. And it's pretty stunning if you look at any number of these search engines to put your name in there, and whether it is where you live, certainly where you work, where you went to school, you might serve on a board somewhere, your biography is online. It is a pretty breathtaking amount of data that is available. And what the GDPR has done with respect to, again, data subjects vis-a-vis the data controllers is be able to say to them, you now have that right to say to them, I want to be forgotten in terms of the data that you have. And you also have the right to withdraw consent that you may have previously given. So no consent in this sense is absolute. So I mentioned a moment ago that it is this idea of the rights that you now have is tethered to obligations that companies have. That's kind of the next piece that I want to talk about, and that is these obligations are pretty significant, of course, from a pure compliance point of view, but also from a litigation point of view, which I know is going to be part of the conversation tonight too. And for companies, the obligations kind of break down in a couple of different ways. Fundamentally, GDPR says you need to act lawfully. So companies now have this affirmative obligation to act in a way with respect to data that is lawful, that their purposes have to be narrowly drawn, that you can't just take data for any interesting metrics purposes, but rather you have to pull the data and use the data that's specific to a purpose that you have in mind. You also have to do something called data minimization, which is something that in the criminal law context people know about if you've ever, in the criminal law context, participated in Title III wiretaps, right? This idea that the government can only obtain information if they have a wiretap on you that they need for purposes of their investigation. in this context, it's somewhat similar, that the data that's being obtained from data controllers about you has to be done in such a way that they minimize just what they specifically need from you. They have to do it accurately, right? The data that they are maintaining on you, and they have to keep it up to date. There's issues related to how they store the data, the integrity and confidentiality of the data. And one of the most interesting is the issue of accountability. And I put a couple of sub-bullets under there. There is much more now built into the GDPR about affirmative obligations that companies have to do, whether it is the specific hiring and appointment of a data protection officer, depending upon how much data controllers control. This idea of something called privacy by design and by default, right? This idea that companies now need to affirmatively build into their processes and things they do the concept of privacy. And then privacy impact assessments. There are now specific forward-leaning things that companies have to do that they really never had to do in many ways before. So let me now go to this issue of enforcement. And I will...
Can I stop you for one
Yeah,
sec
of
just to
course.
ask a question? And maybe you mentioned this, but I just want to make sure everybody understands. What is the data that the GDPR pertains to? Like, is it just European citizen data, or is it European citizen data controlled by other companies? What's the breadth of the GDPR?
So it's personal data, which is pretty broad in scope, and it's interesting in terms of its comparison to the CCPA, which Dominique will talk about, in terms of how that information is described, but it's everything you think about in terms of what personal data would be. But it is for data that is leaving the EU and that is transferring out. Okay. So it's from data that's from the EU. The reason it has, as we talked about before, this impact on American companies is because of the amount of work that American companies are doing in the EU. And as a result, information that is being taken out of the EU, these American companies are now having to think about it. And it's an interesting segue when we talk about sanctions, because for companies that are doing work here in the United States, but they also touch upon European Union countries, this is having a big impact on them when they are thinking about how they maintain, whether it's in the cloud, for example, which may not even necessarily be in the EU itself, but involve EU citizens, or it's information from the EU that's migrating out of the EU. Then there's issues related to whether or not the data is going to another place that is adequate to receive that information, which is where you start seeing the connections between EU data and everything else around the world. The sanctions, which are critical to any conversation about any kind of enforcement regime, is probably the most important, because it tells you just how much of a hammer this regulation can be for companies. And it is pretty significant. It's 20 million euro, or 4% of that worldwide take that companies have. So it has a pretty significant impact. And we've already seen some of it. It's only been about a year, as you know. But we've already seen some of the results from enforcement that's trickling out from some of the member states. France, for example, recently fined Google 50 million euro for the things we talked about: lack of transparency, inadequate information, lack of valid consent related to ads.
There's no centralized enforcement done by each member state?
There is no centralized enforcement. Each of the supervising authorities have the ability to do enforcement of the GDPR. And I'll tell you, it's interesting you say that, because
But who is that? It's like the Federal Trade Commission?
so in France, for example, it is the privacy regulator in France that enforce that.
But there's not one for all of Europe?
There's not one for all of Europe.
Oh.
And it's interesting because you see that comparison now here in the United States, where the conversation, which we'll get into, I think, is whether there should be a federal regime for privacy, or should you have a bunch of states like California and maybe New York that go about and occupy the field in the absence of a federal privacy regime. And you can see where there is differing applications of the GDPR in terms of how different member states are looking at it. So, for example, recently in April, there was a UK lawsuit that is a private class action that was filed related to a 2018 data breach in connection with Ticketmaster that has been filed. And there are other actions that are taking place in the UK, Austria, Germany, Portugal as well. So one of the other things I'll mention that I think is, and I talked there about lawsuit rights. So you now have, right, the ability for enforcers to go about and sanction, but you also have the ability for individual claimants to file suit, and they can do so in a class action format too. It can be for material harm. It can also be for non-material harm. It could be for, in the Ticketmaster lawsuit, anxiety that was created, non-pecuniary harm because of fear or actual results from hacks, for example, that may have happened from data that was stolen. So there's a wide availability of options now that the GDPR provides people in private, also in public suits. But I want to talk about something else that I think is interesting, and that is this notion of unintended consequences. There's not a law in the books in the history of the world that has not had unintended consequences. And the GDPR is like this too, and I think this is one of the things that's going to be discussed and looked at for years to come. And you're already starting to see some of the people who are affected by the GDPR come out and talk about it. MPA, for example, which is one of the big organizations, obviously here in Los Angeles, is saying that actually the GDPR is impacting their ability to do anti-piracy efforts, their ability to police the internet themselves as a private actor and ferret out people who are pirating on the internet film and TV shows. And you also have people now coming out and also saying that, interestingly, the GDPR, which is designed to give more rights, is actually enhancing the power of the biggest companies in the field that have the ability to pay millions of dollars in fines and in compliance efforts and things of the sort. So I think what you're starting to see now is a little bit of the settling of the dust to determine how GDPR is really going to shake out over the course of time. And I know that we'll talk about it in the context, I think, a bit of the federal privacy law, but I think that this is where you start to see, for something as broad in scope as the GDPR, what this means for us here in California, for example, because there is a California law that is so impactful that as big a state as California is, it kind of almost stands to reason that it might have an impact just as big as the GDPR.
Thank you. Wow, that was the GDPR is such a complex statute, and I think you did an amazing job of touching on the most important points. So now Dominique is going to take us through the California Consumer Privacy Act.
Well, yeah, so, Jeff just set it up perfectly. I think without the GDPR, we wouldn't be even talking about my part of the program here, because Europe was really a big influence on our California legislators. And I've had an opportunity to spend some time up in Sacramento recently. I'm not a lobbyist, but have been, as Judge Segal pointed out, providing testimony to the California State Senate Judiciary Committee on the various bills. And I can say, almost every hearing, there is a reference to what's going on in Europe, what's happening with the European data protection authorities, how are they enforcing the GDPR. So much is implicated. Just very briefly, I just want to talk about the 8 new rights that California, basically the California consumers, and the definition of consumer is so broad, it basically means it's tied to our tax code, and it's anybody who is a resident of California. So anybody who's here for a non-temporary purpose is a consumer under California's new law. And so every California resident is a consumer, and they get 8 new rights. First, I call it an abbreviated right to know, and this is where under 1798.100, this is Cal Civil Code section 1798.100, a consumer can find out the categories of personal information that a company has collected about them, as well as the specific pieces of personal information. And so this carries with it some website, if a company has a website or some other forward-facing notice, it carries with it some general notice requirements. But every company is subject now, if they are collecting personal information from California residents, to a verifiable request from an individual. And so if I had a company, Jeff could send a request to me and say, out of all the data that you have, and there was this statistic I was recently intrigued with, we create 2.9 quintillion of data in our society a day. So collectively, with all the businesses, this is a global statistic, but still, California is the 5th largest economy in the globe. And so out of all the data that you have, company, please tell me the specific pieces of personal information that you have collected about me. And the statute has very specific definitions of what personal information means. It's under 1798.140, and that definition includes things that are even broader than the GDPR. So as broad as we thought the GDPR was, as Jeff touched on, anything that's reasonably, linkable or identifiable to an individual data subject is what the GDPR definition is in Article 4. In California, our definition of personal information under the CCPA is anything that's individually identifiable to a consumer, an individual, or a household. So that is so broad. That includes, anything that could be narrowed down to just an entire household. That's much broader than the GDPR. In addition, it includes certain data sets that were not part or explicitly part of the definition of personal data under the GDPR, things like inferences. So any inferences that could be drawn from a consumer based on their name, their unique identifier for their device, an IP address, biometric information. And by the way, there's been a lot of litigation all over the country about what constitutes biometric information in Illinois and a little bit in Northern California as well. This statute sort of cuts right to the chase. The litigation we've been having in the country is about whether facial recognition data comes within the ambit of the definitions of biometric data. This definition of biometric information in the CCPA just automatically includes facial recognition data. So this is an expansive definition when you get a user request. The second right that consumers get is, I call it an expanded right to know, and that's under 1798.110A, and that includes 4 things that a consumer can know, not only the categories of personal information and the specific pieces that you would get under the abbreviated right, but in addition, the commercial purpose as well as any third parties that the data is shared with. And caution, and just keep a flag, throughout the CCPA, there are references that go back and forth between third parties and also service providers and then persons. All of those terms are defined, and some of them overlap and some are different, but you just need to know that that just a notice obligation as it relates to third parties does not incorporate necessarily service providers. Service providers are those who are providing services on behalf of the company. Third party is just someone, a company that you're sharing with. The third right that is available under the California Consumer Privacy Act is, I call it a detailed right to know about what data is sold, and you hear that a lot. But the other piece of this third right is or disclosed for a business purpose. And what you need to understand is the definition of sale is so broad under the statute. It includes anything that is, it includes things like making personal information available for valuable consideration, which is this sort of broad bucket that encompasses the digital advertising ecosystem, cookie placement, and so forth. So that's a very big and broad definition. In addition to the monetary transfers, any exchange, transfer, processing, or even making data available for valuable consideration comes within that definition of sale. Then exchanges for a business purpose. Business purpose is identified in the statute under 1798.140D, and that includes anything for the internal or operational purposes of the company. And then there's a list of specific things that constitute a business purpose, like auditing, security, debugging, marketing, ad impression counting, and many other things. So that's what you have to include, and the statute is very didactic in terms of how you provide that notice to the consumer. So if you get a verifiable request, it must be provided in two separate lists: the list of data that was sold for valuable consideration, or a separate list for data that was shared for a business purpose. Then there's a fourth right that's developed. If you sell data, there's another right that California residents have, which is the right to opt out if they're adults. And the fifth right is the right to opt in if they're children. And children is not the same definition that you might be aware of under the Children's Online Privacy Protection Act, or COPPA, which is under the age of 13. In the California statute, you must obtain opt-in consent. You can get it from kids between the ages of 13 and 16, and under the age of 13, you have to get it from a parent or a guardian. Then there's a fifth right, which I call the right to access and portability, and that's under 1798.100D, similar to Article 17 under the GDPR. If you provide data to the consumer in an electronic format, it must be in a transportable fashion so the consumer can take it to another platform. Then the seventh right is a right to delete the data, similar to the right that Jeff talked about, the right of erasure under the GDPR, or the right to be forgotten, which is one step further. This right to deletion exists, and this is the one time where the California law is a little bit less expansive than GDPR. There are a number of defenses that companies can assert to the deletion right, and one of them it has to do with, like, if you need the data for internal purposes, for your internal uses, and you don't resell it, then that's a basis to keep the data. So a lot of businesses look at that as a sort of a big sort of catch-all to be able to resist deletion rights that they might get. And finally, this is when the eighth right, I bring it up because there is a right in the statute under the right to not be discriminated against is under 1798.125. And what that means is that consumers have the right not to receive different quality of services or products just on the basis of whether they decide to provide their personal information. There is a carve-out to that right. Companies can provide financial incentives up to the value of the data to the business. So this valuation issue is sort of a big issue, and it ties in with Governor Newsom's digital dividend issue, because most companies, quite frankly, have not sat down and valued the data in every sense. Maybe these are starting to have conversations now within companies to understand, what does this data mean, and if we're providing a coupon, a loyalty card, or a gift card, what is the value of that if we're doing that in exchange for, like, an email address? Okay, so those are the rights, and then they also the corresponding business obligations go with those 8 rights, which are, you can intuit, but there are 3 independent rights, 3 independent business obligations I wanted to point out that are not tied to any specific consumer right that I just mentioned. So one is an obligation to train. So unlike the GDPR, which is it's implicit and it's a good practice to train under the GDPR. It's recommended, and when you go into the data protection officer descriptions, they talk about that data protection officer under Article 37 overseeing training, but it's not required under the GDPR. Under California law, it is required for those employees that will be taking questions or potentially interacting with consumers about consumer requests about their rights. You also have to designate at least 2 methods under the statute for consumers to assert their rights. And one of them is an 800 number. That is something that the consumer advocates feel very strongly about. I didn't mention this earlier, but this bill came around and it became law by virtue of a compromise. It was brought on the ballot originally as a proposition by a very motivated individual named Alistair McTaggart, who basically learned the online ecosystem. He made his career was really in real estate in Northern California, and there's a great article in the New York Times in August of 2018 to talk about him as this unlikely warrior who went up against Silicon Valley and won. He essentially the story goes as he describes it, he rented out a home to a Google engineer, had the Google engineer over for dinner, asked how worried he should be about behavioral tracking, and the Google engineers, as the story goes in the article, said very worried. And from that point forward, it just sort of unleashed an interest on the behalf of this person who really took it upon himself to learn the online ecosystem. So he's sort of been the thorn in the side of a lot of the business community in bringing this on. But one consumer group that was along with him for this journey for the proposition was Common Sense. And they are very concerned about any efforts to change this this designation to of two methods to include, right now it includes an 800 number, as well as if the company has a website notice is a possibility. And then the state AG, General Becerra's office, is working on rulemaking that will clarify how consumers can, how companies have to designate methods, and that's under 1798.185 that rulemaking process is underway. And then also, if this isn't an actual obligation, but if companies want to shift liability to their vendors, they need to understand if the vendor is a service provider, they can, providing services for a business purpose of the company on the company's behalf, then there's certain contractual language that needs to be in the contract that the business will only use the data for the business purpose. If they are a third party that you're sharing data with, meaning that that company can take independent steps with the data, not just use it to provide services to the business, but also have an independent revenue stream by creating reports or otherwise that are separate, then for that you need a contract. In order to shift liability to that entity, you would need a contract that had four things. That number one, the company will not attempt to resell the data. Number two, the company will not reuse the data outside of the commercial context of the relationship, and will not use the data to monetize it on their own, and will certify that compliance. There are a bunch of general defenses, and for time's sake, I'm not going to go into those, but all of these things, definitions of business, personal information, the public availability of data. Now, public availability, I just pointed out because it's not everything that you would think. It's not just when a user like in the EU posts data on a social network site that becomes publicly available data under the statute. Currently, the definition of publicly available is limited to any data that's posted by a federal, state, or local governmental authority, and if that is there, and a company uses it in a manner that's consistent in the way that it's posted by the governmental authority, then that will not be considered a personal information that's covered by the Act. But there are a bunch of other exemptions for financial data that's covered by the GLBA, but there's some exceptions there, or there's some questions about the GLBA exemption because there's personal information is defined differently in the two statutes, so there's a lot to look at. The companies are just like GDPR, they're going to need to be really careful about how they respond to California consumer requests to be able to preserve defenses, because the reality is this is, now having spent more time in Sacramento, I can tell you this is definitely going to be a hotbed of litigation for our state, kind of unfortunately. There's the California Consumer Attorneys Association. I was in a meeting recently about private right of action that involved them and also the ACLU, and they've basically made it clear that whether or not a private right of action is actually in place for the statute, they will be seeking to enforce their rights through, they mentioned...
Are you saying there is, so right now there is no private right of action?
There is a private right of action that's triggered just by, what they call it negligent breach, but it's broader than that. If there's any unauthorized access or exfiltration of data that's caused by a lack of reasonable security, under 1798.150 of the statute, a consumer can have a private right of action to pursue that claim. But they must give...
What's the claim?
Well, the claim would be that there's an unauthorized access or exfiltration of data that is caused by a lack of reasonable security by the company, and so the consumer is saying that they've been harmed just by that, just by that violation.
Is there a specific remedy, like treble damages or liquidated damage?
$100 for unintentional violations and up to $750 per violation. So that can, if there's a class action, for example, that could really add up with all of, if you have multiple records, you've seen these data breaches that have involved millions of records recently in the news. Yes.
Are there any civil penalties if these businesses do not maintain these types of principles that are demanded by the Act, similar to the song Beverly?
Yeah, well, there's, there's just the private right of action, and then there's fines that the state AG can pursue, which are That's up to 2,500 on the low end and 7,500 per violation that General Becerra his office can seek for any violation of the statute altogether. It's not just limited to negligent breach. So conceivably, if a company's privacy notices that I mentioned, in the abbreviated right, the expanded right, and the right to know about what data is sold or disclosed, if those privacy notices or communications with the consumer are inadequate, the AG could go after a company for violation for intentional violations of up to $7,500 per violation.
I hate to keep asking questions, but why not? Are these likely, and can they, or are they already in federal court or state court?
So they're not. So I should have mentioned.
We do. I'm deferring to Dominique on that.
It's coming, and well, let me say, has it come already? I have an associate that tracks every time the California Consumer Privacy Act has been mentioned in briefs, and I think we found just like a month ago, there were already 14 references. The law actually is enacted, but it goes into effect January 1st, 2020. So the plaintiffs' bar is already referencing the act, like California has a commitment to privacy, like is evidenced by the California Consumer Privacy Act and so forth. I wanted to mention, this is a good pivot to the private right of action, which is really at the crux of the debate and what's going on in Sacramento right now. So part of the compromise to get business ended up agreeing that this law should be enacted because Alistair McTaggart had qualified with enough signatures for his proposition. I think he had twice the number of signatures he needed, where it would have gotten onto the ballot.
What was the proposition? When was it? A number?
Yeah, the proposition was had the same name, the California Consumer Privacy Act. He got the requisite signatures to place it on the ballot, but in sort of a hastily arranged negotiation that happened within a 5-day period, Senator Hertzberg, Assemblymember Chow, and Alistair McTaggart and his group, which is Californians for Privacy, worked on a compromise where Assemblymember Chow would carry the bill, and then Alistair McTaggart would withdraw his proposition. So it never did get on the ballot, didn't get a number, but it would have qualified. And the concern there was to make any changes and tweaks in the statute, it would have, potentially caused a need to have a supermajority, which a legislature did not want. So business went along with this, but with the understanding that the private right of action would not be expanded. That was the compromise, that was the deal. Then came along Senator Hannah Jackson that sponsored a bill that was actually brought forward by General Becerra. So General Becerra wrote a letter in August of 2018 to the legislature to say, wait a second, nobody talked to our office about this compromise. We weren't involved in this, and all of these duties for enforcement in terms of, there are a bunch of things I didn't mention, but there's when a company is sued, they have a 30-day period to cure. And if they don't cure, then the consumer can bring a private right of action. There's advisory obligations that the AG has to answer questions from business. And they said, wait a second, we are not like the private law firm for all of business. We don't have time to do this. The law also calls for business the law also calls for the AG to promulgate regulations. On their website right now, 1,034 pages of comments from different stakeholders about what the regulations should look like. So they've been very, very busy. So there's so much going on. I just want to point out that the private right of action issue is on the table. It's still with Senator Hannah Jackson. She's very stern towards business, and you guys can hear the hearing. It's on your slides. There are a bunch of other bills that just made it out of committee on Tuesday. They would have died otherwise, and these are very on the slide, very pro-business propositions that the business community put forward. Probably one of the most important is Chairman Chow's bill, AB 25, that is made it out of committee, and that would exclude employee or contractor or vendor, like independent contractors and employment-related data from the definition of personal information from the statute. So that would be really great. California is not the only one. We counted 17 other states that have a CCPA-like bills. Washington State just got withdrawn about 2-3 weeks ago. So some have even started asking the question. So in order for data to flow between Europe and other countries without having some kind of other adequacy means, they can get a decision from the EU that the recipient country is an adequate country for purposes of privacy and data security controls. Japan recently got this. Canada has it from the EU, and so data can flow back and forth without some of the problems that you guys have in litigation. Someone even asked the question. This Harvard student wrote an article like, "Should California now seek adequacy under the EU?" which I thought was pretty funny. Look, there are 133 data protection laws throughout the globe. Uganda was the most recent. I have a theory that if companies start, on the business side, I advise a number of companies, if we start treating data like an asset, we actually start looking at it at board meetings, and CEOs and C-suite folks start thinking about it and managing it like an asset, that we have a way forward. I outline these things in a book that is on Amazon. And with that, I'm going to turn it to Jason.
An amazing sweep of tremendous amount of information. So thank you, Dominique, and I'm sure you made everybody curious to learn more about it and worried about it. So now Joel Richlin is going to talk to us about the perspective from the in-house lawyer and what these privacy statutes mean for large corporate entities.
So I don't know the answer, but I'm very grateful to be here on the panel, mostly because, I'm in charge of litigation for our company, and we have 45 hospitals in 14 states. And I have been hearing every day from our outside counsel, "Hey, Joel, got to talk to you about this. There's this new law, a couple new laws. I mean, going back to the GDPR when that came out, got to talk to you about this. There's something you need to know about, and you have a problem, and you need to know what to do." And, and sometimes I take that with a grain of salt, but enough people have been saying it to me. I have been trying to figure this out. Jeff you never mentioned this to me, actually.
I will tomorrow.
But lots of folks have been mentioning to me, and I have been trying to figure it out, and I don't know what the heck to do. But I can share at least, think through with you and some of how I've been thinking about it, and I can't speak for all business, but for one hospital system, I can tell you how we're thinking about it. My starting point for this is that, I think businesses want to comply. We're trying. We want to get it right. We don't want any problems here. We want our customers, patients, business partners to be happy and satisfied. And so I'm in the healthcare business, and we're a highly regulated industry already. So it's built into our DNA that we have a lot of rigor around data security and privacy already. The hospital system is not a data company, but we have more data than anybody, right? We know everything about you. And so we're very good at protecting that. And storing it for a really long time. We're under state and federal obligations in every state to retain data for sometimes 25 years and more. Every patient record under certain regulations often needs to be held for 25 years that we're required to maintain it. Now, that is up against a backdrop of us being under attack. Our server and our IT gets attacked thousands and thousands of times a day from hackers and worms trying to breach our system. So we spend an inordinate amount of time on data security. And one example you may remember, which was very recent, was the WannaCry ransomware attack in 2017 that ravaged health systems. Whole hospitals shut down. And our system had a very robust response to that. And we were successful in not having any issues there. But the whole company was engaged in an effort to secure ourselves from that worm.
Can I ask, is that motivated by, people who want to steal money from you? Or is it a sort of a terrorist kind of thing? Or
yeah, I think that was just to cause problems.
Yeah.
That was the one that would come in and lock up your system, and you couldn't access it, and it
They just have a
instantly
beef
spreads
with
to
your
everybody.
company and they want to do it.
I think they just want to make a statement.
They want to make a statement.
Because by that point, you're not going to write a check. Your system is shut down, and you call the FBI, and but you cease operating. And we did lock
Just
down.
malicious.
Yeah, I think so. And we had to actually lock down certain things throughout the day, and actually, we took extraordinary measures to do that. So we're very used to that, and the reasons are, number one, we can't afford to fail. In our industry, you're probably familiar with the Anthem data breach. where they paid $115 million to settle a class action and $16 million to the United States. We're a big company. We can't afford to do that. Anthem is a little bigger, and they could, but that had to hurt even them. And not only can they not afford to do it, they don't want to. It's not good for their brand or reputation. This happens all the time in healthcare. One of our other colleague health systems recently had a data breach of 3.7 million patients, and recently one of our colleague hospitals, not us, but in San Diego, a very large, prominent health system, you may have seen in the news, just got sued for inadvertently recording women in labor undergoing C-sections and in OB rooms. And really what happened there was they were just trying to do a security measure, and they had automatic video cameras with motion sensors, which were trained on the pharmaceuticals in the operating rooms, and they were trying to catch people stealing pharmaceuticals, and they inadvertently recorded all of these sensitive procedures. So that's just devastating for anyone to go to that hospital ever again. The point is we want to get it right. We can't afford to get it wrong. And this, also in the news, you've probably seen in terms of privacy, this sort of delete Facebook movement where, consumers are really voting with their feet and they're interested in having control over their information. The counterexample of that is you've seen Apple trying to differentiate itself in terms of privacy. So as I said, I've been thinking about this in terms of litigation. My company gets sued on average every day of the week. We got sued. We got sued today from MedMal in Michigan. We get sued for something every day, sometimes more than once. And what I really try to focus on are matters of systemic risk. And to me, these statutes really do have systemic risk because of class actions and government enforcement. And that is really what I pay attention to. Anything with a class action or a government agency is a problem because the penalties can be too severe. So, I've thought a lot about the GDPR. I think Prime is okay from that because we really don't have extraterritorial reach. But we're going to make sure that stays that way. Obviously, for an international company, it would be different.
Not to play devil's advocate, but what if European citizens are getting treatment at your hospitals?
So,
like they're traveling in the U.S., and it's probably a small percentage, but wouldn't you be subject then under the GDPR?
I don't think we are because we're not there.
It's information that's going from the EU here to the United States.
So you have to have an operation in the EU.
Or if you have operations in the EU, or if you're targeting, for example, if you're saying,
advertising into it.
that's right.
So just someone getting treated here is not enough.
Right.
Okay, but what if their medical records were sent from a hospital in Europe to the United States? Then it clicks in? Okay.
Can I follow up on that issue? I've been trying to figure out where you get jurisdiction and who's applicable. Is it applicable to the consumer? Is it applicable to the information? Is it applicable to where it's stored? Can a company put its server someplace and get out of this by having a server someplace? And alternatively, if I do business with, and I don't live in California, I live in a non-state, but I do business with Citibank that does business with the European Union, can I then sue Citibank for violation of the GDPR because they're obligated to protect my information, particularly if they somehow end up with a server of it in Europe?
Turn over to the expert. I have an opinion, but I'll hear what you say.
Well, I'll remember that GDPR is fundamentally an EU-facing set of regulations, right? So to the extent that what you have is for EU citizens, these violations occurring, even if for, say, a Citibank, they are outside of the EU, you could have a cause of action there. The question is, could you have a cause of action here in the US? I will tell you that where you've seen some of this litigation, it's been kind of focused on the idea, it's almost kind of ancillary to the GDPR itself. Instead, it is, for example, more of your security style litigation, which is to say companies that are making misrepresentations about their GDPR compliance, that you're starting to see some of that litigation here in the United States related to that. But otherwise, it's litigation that is EU facing.
Joel, where does HIPAA come into all this?
So fortunately, HIPAA is carved out of the CCPA. So, any hospital has an enormous amount of patient information and patient records. So, one of the things I was going to talk about is there's a couple limitations, and Dominique can correct me if anything's changed, but what I've been trying to figure out is it doesn't apply to nonprofit businesses. So in California, an inordinate number of hospitals are actually nonprofit hospitals. So Prime Healthcare owns 15 hospitals in California. Some of those are nonprofit hospitals, but actually most of them are for-profit hospitals. One of the issues operationally, we have 30 for-profit hospitals and 15 non.
Papa Bear, a profit company?
What?
Prime Healthcare, I think.
Prime Healthcare, a profit company?
Yeah, we have two parent corporations. We have a for-profit and a nonprofit. Yeah, so the nonprofits are owned by a totally separate entity, a nonprofit 501c3 foundation. So, but operationally for us, we can't differentiate that way. We everything is centralized. So we can't have different data or privacy rules for Encino Hospital because it's a nonprofit, and then Centinela, which is over in LA, have a different set of rules. We really just need consistency and uniformity. And it's the same problem with California and other states, right? We're in Nevada and Texas and Michigan and Ohio and Pennsylvania, New Jersey and Florida and Alabama and Georgia, in addition to California. But it's, for us, the way I would look at it, it's almost a race to the top. We just have to comply with what's going to work everywhere. I can't come up with, 14 different policies.
Right.
So I need to do
agree.
something that works for California and implement it anywhere. We do, because California is so crazy, we do sometimes make distinctions.
Yeah.
Where it's a really painful operational policy, we will operate California differently. But that is very hard for us to do.
Yeah.
Because there is so much movement between our company and everything is centralized. So making those distinctions is really hard. So even though there is a carve out for nonprofit providers, because we're also a for-profit system, we basically have to comply. The CCPA does carve out your typical medical records, which are governed by other statutes. And as I mentioned, so we're very comfortable complying with those, but those are really data security and privacy regulations that they don't have any of these rights to them. And I'm really uncomfortable with these. And so, for example, the right to know, we can't individualize something. So, we have, 10,000 patient encounters a year at a hospital, and if every patient can ask us a question about their data, we can't answer that question. And in terms of opt-outs and opt-in, we have no way of tagging you if you tell us you want us to do something different with your data than everybody else. That's impossible for us to do. We're not a data company. And even the differentiation between ages, 16 years old, I referenced our obligations to store medical records. So there's in different states, if you're a minor, you actually have to store medical records longer. What do? We store all the medical records for the highest period of time. We can't go through and figure out this medical record is a 17-year-old and we're going to keep it this long. So there's no way I can operationalize an opt-in or an opt-out, and I have to find a way to do something that works for everybody. So, and the right to delete, I have no idea what we're going to do, because again, you come to our hospital and the patient records are going to be exempt, but we have a ton of financial information about you, because we send you a bill and we need to have your financial information. And goodness, if employees are
Still in this.
we have a ton of information about employees, and if you ask us to delete something, we would have to have a full-time department just to do that.
Are you preserving everything in the entire system for 25 years?
Medical records. Yeah, medical records have to be preserved. So your patient chart, when you get treated at our hospital, so medical records have special regulations about retention. So, the doctor's notes, everything. A medical record actually has a legal definition under state and federal law.
X-rays?
Yeah, part of the medical record.
So if I want my X-ray from 25 years ago, I can I can call up and ask for it?
You'd have to pay for the trouble, but you could probably get it, yeah. It might be in storage and we'd charge you for that. Yeah. But we get subpoenas for medical records literally every day, hundreds a day. I mean, that's a huge, as you can imagine, from lawyers all over, everybody needs medical records for all kinds of things. So we're very good at that, but all of this individualizing anyway is quite frightening and concerning to me. So we're just trying to figure out those issues. As I mentioned, and Dominique talked about, and it was referenced in questions, there are significant litigation risk and penalties, and anything with, as we talked about, anything with a class action, even with a small dollar penalty, when you start to talk about class actions, given the volume, it's just tens of millions of dollars. Yes.
I might have missed this when you were talking, but I understand that there is a carve out for information governed by HIPAA. You're talking about these other elements of compliance, right? Posting a privacy notice and everything. But if you're an organization that's governed by HIPAA, I know that. What is the extent of your obligation with the CCPA? Like, what exactly is that HIPAA carve out?
Well, I mean, just to jump in with what Joel was saying, it's the PHI and the PHI for HIPAA, and then medical information under the California Confidentiality of Medical Information Act. The issue is that some of those definitions don't line up, like with PI under CCPA. So like things like inferences from if they're doing any AI in the hospital or so forth, that would come under 1K, which is inference data from everything else, and that's not in there. Also, the other issue is like de-identified data. The definitions of de-identified and HIPAA are, you can get an expert to agree that you've de-identified to a sufficient level, or you meet those 28 steps. But in California, there's like a very specific definition about technical controls that need to be in place and downstream user contracts and so forth. So there's that. And then clinical trial, there's a bunch of differences that don't quite match where data falls out.
So all healthcare organizations then need to, in California, right, having the information of California residents need to comply with CCPA.
They need to look at it at least.
It's not giving you additional regulations governing PHI and medical records, but the remainder of the.
Well, we have a ton of other data, financial data and otherwise, that would not qualify as the medical record or PHI. Yeah, because anytime you go into a hospital or any healthcare provider, Anthem, your insurance company has just as much information about you as we do, and it's a lot. And the other real concern we have, as Dominique talked about, is sales. Right? We're not a data company. We don't sell data, but we have a ton of necessary business partners and vendors which we share data with. We could not operate without, and so we're going to have to figure out
that should
what
be
to
exempted
do
that
there.
from the sale.
You got an example? Who that would be?
So, revenue cycle, collections, patient collections, lots of business partners that we interact with on a daily basis that we need to share financial information with or your medical records with. All right, so sort of to wrap up then, thank you. Trying to think about the kind of guidance that business needs and we're looking for. Number one, right now, everything is still sort of up in the air, right? Because we're sort of trying to prepare for the worst of what is going to go in effect if nothing else changes, but we're hoping that things change and we just don't know if it's going to get better or worse. So it's kind of a moving target at this point. So, we're trying to figure out when to pull the trigger on actually implementing something. So that's number one. I think from my perspective and most businesses, I think we really need industry-specific targeted guidance. So, general rules just aren't going to make sense for hospital systems or the healthcare industry. I think every industry, as specific as you can be, is going to be really needed and helpful for business. Sample policies and procedures, things that we can sort of take a starting point and then just customize to our business. In terms of getting guidance from outside counsel, We're really looking for demonstrated knowledge of operations, and recommendations, and I put down must-dos, should-dos, and could-dos. We're trying to figure out, what do I really have to do? What is probably a good idea to do? And what might I do if I can afford it and have the time? So we're trying to sort of triage and figure out what those things are. We're really paying a lot of attention, trying to figure out what our peers are doing, what other businesses, what other hospital systems, what other healthcare entities are doing, and trying to steal good ideas and move in lockstep. And we're trying to find an efficient way to do it, because we can't have a team of lawyers come in and just do a deep dive reviewing everything we do and coming up with different proposals and compliance programs. We want to get it right, but we need to do it in a way that makes sense operationally. So.
Can you buy insurance to cover breaches and all this stuff?
So we have data breach insurance. It's very expensive. We have had a data breach. You can't really insure against a lot of litigation. And I'll tell you something else from a business perspective. We have had experience and seen our peers who have catastrophic insurance for certain big picture litigation matters. And I'll tell you, when that happens, the insurance company denies coverage. That one time where you have a catastrophic risk 20 million plus policy, and then you make that claim, you're going to end up in litigation with the carrier. And I've been through that several times. So.
On that happy note. Yes, you have a question?
For Dominique, are there any fee shifting provisions for plaintiff's attorneys? If there is,
No,
okay.
and that's the issue, that there's a height. Someone from the ACLU gave a statistic that this is polling at 94% for consumers to have a private right of action to enforce the entirety of the statute, and that was mentioned at the April 9th hearing before Senator Jackson. So
no attorney fees yet.
No fees yet.
No.
Stay tuned, I guess. I'll go very quickly through these last points. So my goal was to talk a little bit about what potential impact, and a lot of this is speculation, these privacy laws would have on federal litigation. I think any private right of action or enforcement action is likely to be brought in the state courts and not in federal court. But obviously, if we eventually get a federal privacy law, that might change. So from a purely discovery, how is this going to impact the disclosure of information in litigation perspective? I started with what is our historical treatment of privacy in federal court. And I see this very often, that in discovery, people would be asserting a privacy objection to the disclosure of financial information, personal information, health information. And, I have to repeat that if it's a federal question case, federal law governs the privilege. Federal law governs the question of the privacy right. So there's a very limited recognition of privacy rights in federal law. So if you're asserting privacy, or even a California statute as a right to privacy as a basis not to disclose information, the federal courts will basically apply a balancing test. And that's talked about in this Soto case. But we generally look at the privacy interest involved. How serious of a privacy interest is it? We usually recognize a very heightened privacy interest in sort of medical information or something that's highly personal, in contrast to other kinds of information that you would describe as having a privacy interest. And we weigh it against the relevance of the information to the litigation. And then we also ask the third question, given the privacy right, given the relevance, can a adequately drafted protective order guard the privacy right and still enable the information to be disclosed for the litigation? Very different than the classic California privacy right that's asserted when we have a diversity jurisdiction case. There's a much stronger right to privacy recognized in California law that we're obligated to uphold in a diversity case. So that's the way we apply privacy in discovery situations. So I don't think that any of these statutes are going to dramatically affect our treatment of privacy issues in federal question cases. You click it's right here. Diversity cases, I think we will struggle very much in California as to how to apply the CCPA. And what's this going to mean for the production of documents and other information in federal cases? Is it something we're going to bring up with the proportionality factors? That is, if it's a violation of this new statute, is that another factor for the court to consider when deciding whether or not to order production? Is it something that parties should be including up front in a stipulated protective order? Should there be, optional standard language in the protective order recognizing the CCPA requirements? So those are all things that we're kind of talking about and wondering about how we should be addressing them. On the question of the GDPR and foreign privacy laws, can it be asserted as an objection to production of information when litigation is pending in the United States? It really hasn't happened. I've seen it asserted in a couple of cases in which I've been managing the discovery in the case where parties did not want to turn over information claiming that it would be in violation of a foreign jurisdiction's privacy law. They'd have to comply with that privacy law. The expense and burdensomeness of the production would outweigh the value of it. And so this is sort of the case that a lot of people are looking at and citing, this Royal Park case. Basically, the defendant in that case was seeking to compel the plaintiff to produce documents from custodians located in Belgium. The plaintiff asserted that both the Belgian, and this is sort of a precursor of the GDPR, the European Union privacy laws, prohibited the, quote, processing, which is the same as producing in litigation, of personal information. And basically, the law is that if the foreign law that you're looking at, whatever state's or country's Privacy Act, conflicts with the United States law, then the court has to go to a comity analysis. But in Royal Park, the judge assigned to that case initially found, I looked at the Belgian law, I looked at our law, I didn't find such a conflict. So no conflict, no problem. She actually went on to do the comity analysis afterwards, which is requires the consideration of 7 different factors. So if a court's actually going to find, and I think a court could find a conflict between the GDPR and our typical laws on disclosure, we're very generous about disclosing private information in federal court. As I said before, we tend to err on the side of disclosure in American discovery. That is our norm. And we generally say in federal court, if you can have an appropriately drafted protective order to address the concerns, the privacy concerns that are raised, we're going to order it disclosed. That's somewhat in conflict with, I think, a lot of the things we've heard earlier tonight about the protections of the GDPR and the CCPA. So if you found the GDPR in conflict with the United States law on discovery, there are these 7 factors the court has to look at. The importance to the investigation of the information requested, the degree of specificity of the request, whether the information originated in the United States, the availability of alternative means of securing the information, the extent to which noncompliance with the request would undermine important interests of the United States, or compliance would undermine the interests of the foreign jurisdiction, the hardship of compliance, and the good faith of the party resisting discovery. 7 factors to apply. I predict there will be more findings of no conflict because I think it's easier for the court to say, it's not such a big conflict here.
And those 7 factors coming out from the restatement?
Yes. Actually, 2 of them come from a published decision in a circuit that added the last 2. The first 5 are in the restatement. But basically, the comity analysis is going to have to follow this kind of discussion as to whether or not a federal court can order the disclosure of information over the objection of the GDPR or European privacy, or frankly, any foreign privacy law. So, the question is, if the GDPR is going to make it more difficult for entities to obtain information in the European Union, would that cause any increase of people coming to the United States for companies who own that information to produce it in the United States? And there is a statute, 28 U.S.C. Section 1782, that provides a right of action. It's just essentially like a petition that one can file under the statute in federal court to compel somebody in the United States to produce information for use in a foreign jurisdiction. So if you have litigation going on in Europe or another country and you can't get the information because of that country's privacy laws, are you going to come to the United States and try and get that information from that company in the United States? So, we haven't seen a dramatic increase, although me and my colleagues have been talking about it. I certainly have gotten a couple of these petitions since in the last couple of years that I think are in part caused by the interest in getting information out of the companies here in the United States. If you plan to use 28 U.S.C. 1782, there are 3 statutory factors that have to be met. The application for information has to be by an interested person for use in a foreign proceeding, and the person from whom the discovery is sought has to be either a resident or found in the district where the application is filed. So in some of these cases, they've been major corporations in the United States, so they are going to be found in many of the federal districts around the United States. For use in a foreign proceeding is very broadly interpreted. So if you're planning on bringing an action in a foreign country, if it's ongoing, if it's on appeal, if it's likely, that has been found to be for use. So it's a very broadly interpreted three factors. Then beyond the statutory factors, there are a multitude of discretionary factors for the court to look at, whether or not they're going to order the production of that information in the United States. I won't go through all of them, but they're listed there on the slide. I think that the California statute is going to create a lot more problems for us in federal court than the GDPR. Remains to be seen if over the course of time people will start using this statute to get information in the United States. The last topic is, what's the status of a federal privacy statute? So I turn that over to the experts. Where are we with that, and how likely is it? Have there been any bills introduced?
Well, Senator Klobuchar introduced a bill, and so did Senator Rubio. Therefore, Senator Wyden, Senator Thornton have draft proposals that are similar to, basically it is similar to a GDPR type model. Klobuchar's bill is not as broad as GDPR, but still providing a lot of rights to that are brand new to all U.S. citizens. There is a private right of action, and one of the ones that I think there's a senator from Hawaii that introduced well, he didn't introduce it, but he has a draft bill that would include jail time for companies that fail to, the officers of companies that fail to comply with privacy laws. But the issue, I was just in Sacramento on Tuesday because of these big hearings about these 8 bills that the Assembly was considering, and then there was one in the Senate that ended up being pulled. But I was talking with a lobbyist from DC on behalf of the software industry, and many other companies, many other lobbyists that we've talked with, and there were a couple of articles that I passed around before coming here, and the Julie Brill, who's the Chief Privacy Officer of Microsoft, put the odds of a federal bill at like 30% that would include preemption of the California law. Other lobbyists talk about a 3% possibility that will happen before the end of the year. Apparently there's a feeling that in the United States Senate, for some senators, unless preemption's on the table, there's no discussion about privacy, which is definitely a position that a lot of business feel that a big point of the federal law would be preventing all of these state laws from proliferating. But that sort of led to sort of stalemate where the California contingent apparently is, because of the popularity of the California Consumer Privacy Act, that was pulling it over 80%, and now this idea of a private right of action is pulling it 94%, according to this ACLU study that just came out a few weeks ago. There's just a big reluctance on behalf of, I think, California legislators, both at the state and federal level, to disturb that, what they consider to be the will of the people. So right now, there's definitely been efforts. I know the business community has been, across industry, entertainment, retail, big tech, and so forth, have made the rounds in DC to see if something can be done. But I personally, just stepping out on a limb, I personally think it's going to be unlikely that something gets accomplished before January 1st, 2020, which is the effective date for the CCPA. And so that's sort of forcing, some, as Joel was mentioning, some compliance efforts by companies to just start thinking about this now, unfortunately, because I just don't think anything's going to get solved before then.
All right, we have made it to 8:15. Question?
Yeah, I have two questions, two quick ones. So regarding preemption, aren't states allowed to grant more or give greater rights than the Florida or the federal law, number one? So I guess would preemption actually be a factor since California is so generous with its statute, number one? And number two, how does law enforcement feel about the California law in terms of data collecting and surveilling the population in general? Of course, that doesn't happen. But.
It's interesting, there is an exemption under the statute for having to comply with 1798.145, talks about if you have to comply with any federal local laws. There's also if you're defending or investigating a claim. So I think maybe that's why we haven't seen law enforcement really come out in any of these. So what's happened is there's been a lot of public activity the first quarter and now in the second quarter as well. So first of all, the General Becerra's office held public hearings all throughout the state starting January 8th all the way through March 5th or 6th. In all different parts of the state to just collect information from stakeholders to find out what they wanted to see in the regs. And so we've seen a bunch of different people stand up and make statements, and so we kind of get a sense of where people were coming from. And then the AG's office gave until March 8th for written comments to be submitted so that they could take those under submission before rulemaking, which is a little bit unusual because normally they would just issue the rules and then there's a notice of proposed rulemaking and then people can comment on that through that formal process. But because this represented such a sea change, they opened it up. So I haven't ever seen, we covered all of those hearings. I never saw law enforcement come out against it. But the only thing I have seen is on the AG side of the house for enforcement, they really see themselves as an enforcement body. And so they don't like these ideas of having to give companies the right to cure issues for 30 days and to hold, and if they cure it, not being able to pursue litigation. That's something that I know General Becerra's office has, he wrote a letter about that in August, and they've been pursuing it in all these hearings.
But also like the right to delete, that could be potential evidence.
Yeah, so the deletion right has a bunch of defenses. I didn't go through all of them, but one of them is if you're investigating fraud, for example, that is a defense to deletion. If you have, another legal obligation to retain the data, if there is some contractual necessity to keep the data, there's about I think 7 enumerated defenses that are pretty broad, and then you've got the exemptions for certain things that are so the defenses are in 1798.105 in the deletion right itself, but then there's general exemptions for having to comply with federal or local law or defending a claim that are in 1798.145. So I think businesses generally haven't said that.
I think it raises a very interesting point, though, that I've heard debated is what impact do all of these laws have on an obligation to conduct a litigation hold? If you, we always have a lot of fighting over when is the real trigger date for the litigation hold, right? When you have reasonable notice that litigation is imminent, and what's the scope of the litigation hold is another fight. So if you have an obligation to, delete information upon request, should you ask yourself whether or not that particular information will be encompassed in a litigation hold that you might have reasonable notice of? So I think that could create a lot of really difficult questions.
Yeah, it's a really good point.
So thank you so much to this great panel. I'm really appreciative to Jeff, Joel, and Dominique. I learned a lot, and I really appreciate your time. Thank you very much.
Thank you, Judge Segal.